Morning, everyone. We will give a couple of minutes to just clear the lobby and get everyone to join us today. Okay, I think we've had a chance to clear most of the people in the lobby. We will add in invitees as needed. So thank you very much for joining us today. I'm excited to present to you on medical leaves made simple. My name is Ryan Hafner. I'm the Vice President of Operations in our Return to Health team at Cowan Benefits Limited. Excited to be joined today by Sean McAleese, who is our partner with Davies, Ward, Phillips, and Weinberg. Sean specializes in employment and labor law in both the private and public sector. Has been a great partner with Cowan as well, recently having presented at our Think conference. And he's joining us today to present on recent changes in labor law legislation with a focus on long-term medical leaves and what it means for you as an HR representative, professional, your organization, and your employees. So with that, I welcome Sean.
Thanks, Ryan. And good morning. It's still morning, everybody. Pleasure to be with you, even albeit virtually. As the title slide implies, we're going to hope to make medical leaves made simple. But I must confess, as I go through it, I'll probably make it somewhat more complicated than you were hoping. But the good news is you've got folks at Cowan who are quite experienced in managing these processes. Because as I go through it, you see the process is quite critical. So what I'm going to cover today is the legal framework around accommodation and absence management. And then I'm going to address how the most effective ways in which to manage these absences. And then, of course, ending off with, as any good lawyer would do, is to scare you a bit about the risks if the process isn't deployed properly. Aside from just simply, meaning the absence is extended, or the individual commences a human rights claim or other issues, and we'll sort of deal with that towards the end, because it is an area that's fraught with difficulty, unfortunately, because you're dealing with employee health and to some extent employee privacy issues. So first, on the legal framework, as everybody knows, the foundational statute for this issue is the Human Rights Code, and everybody has the right to freedom of discrimination in respect of their disability or being harassed or treated unfairly as a result of their disability. And then obviously that can extend to absence and accommodation management. So that's the foundational piece to start us off. And I just thought, because a lot of people don't go back and look at it. And it's quite interesting. The Human Rights Code actually contains a fairly exhaustive definition of what amounts to a disability. Obviously, the ones we're all familiar with in terms of physical disability or disfigurement or bodily injury. But you'll see there's quite a bit of specificity around it, including diabetes, mellitus. It also even goes down to speech impediment. Reliance on an animal, a service animal, itself constitutes a disability. And that's something to sort of bear in mind. The other broad category, obviously, is any sort of, and increasingly, and you probably vouch for this on your end, it seems to be it is more of a mental impairment, mental addiction, mental health issues, which are creating a lot of absenteeism and or difficulties around the accommodation process. And we've certainly seen a lot of employees post-pandemic attempting to leverage the disability as an accommodation claim and to insist on working from home, whereas other employees have obviously returned to the office, if not entirely, at least partially. So it's an important area to deal with. Learning disabilities, mental disorder, as I mentioned, and then just the other. Sometimes we also lose track of this. My apologies back. The a disability under the Human Rights Code also includes somebody who's obtained benefits through the WSIB, so they've established a claim, and so that is entitled to. They're entitled to deal with that as as a disability under the Human Rights Code, as well as under the WSIB. Under the WSIB, there is also the legal framework that we need to consider, which is if it is an injury that's related or arises from the workplace, there are certain statutory requirements over and above the Human Rights Code or the Employment Standards Act. And that's the duty to cooperate, which applies to the employee, and the duty to reemploy, which obviously applies to the employer and, in a sense, their agent in terms of who assists the employer with those issues. Another legal framework to be aware of is to the extent that you or somebody assisting you, if you have a particular statute that might apply. So for municipal HR folks who might deal with, for example, accommodation of police officers, there's specific rules and requirements that are also layered into the Community Safety and Policing Act, which recently, I was saying it says 2019, it only came into force last April, but essentially governs the employment relationship with respect to police officers and civilians. And so that's certainly something that you would need to consult if you're dealing with a particular subset of employees. The Employment Standards Act, which again you're all familiar with, sets out, I sort of say, various and sundry leaves. It's quite incredible how long the list of leaves has become under the statute. The ones of immediate interest, obviously, are the 3 days of unpaid job protected sick leave, and the restriction on employers effective October 28, 2024, which prohibits the employer, or obviously the agent administering absenteeism for them, from requesting a doctor's note. But it's important to note that there's, with respect to all the other leaves, including sick leave, there still is the ability to request evidence that's reasonable in the circumstances. It just can't be, obviously, with respect to sick leave, because of the ban or the prohibition, it can't be a medical note. But to give you an example, I mean, we've had cases in which we've uncovered sick leave abuse or fraud by asking, they say, well, I'm taking one of my 3 days under the ESA, and we've asked for example, this was an individual who had left the country, and they claimed that they were too sick to return, and they provided a basic doctor's note, in prior case they did. In this most recent one, they didn't have to provide a note, but they did anyway. They just voluntarily did it, but the employer couldn't rely on that. So what we asked for instead was, we want to demonstrate whether or not you actually had intended to come home at the time you did, and they requested the tickets to show the flight, to show the dates that they left, the dates they returned. And when they requested that, it turned out that the individual had never actually booked to return home on the date they said they were, and had in fact extended out 3 days, which is ultimately what they requested under the Employment Standards Act. So we're able to rely on that evidence to say that it wasn't a proper leave. But you can't get into challenging the medical basis for the illness for the 3 days. But bear in mind, once that 3-day Employment Standards Act leave period is covered and done, which you would apply to the first 3 days in the year, then any subsequent time off, because usually employers have weekly indemnity or other sick leave programs, you can certainly request doctor's notes for those absences once you get past the 3-day threshold under the Employment Standards Act. The other leaves, which I just leave here, I'm not going to go through them, but as I said, I was going to give them all individual bullet points, but as you'll see, that have about 14 slides to set out the various leaves, but they all are subject to the same rules, and some of them may involve, obviously, mental health issues. For example, somebody may take a critical illness leave or a crime-related child disappearance leave because they're quite understandably stressed out, and they might have medical for that. But again, that's a different issue than the 3 days of unpaid sick time. So and the evidence reasonable in the circumstances continues to apply. So you could certainly, when you're managing that form of absence, even though it's a statutorily protected leave, there are certain requirements that could still be satisfied. Now, with that foundation in place, I'm going to deal with how the absences are managed, obviously by human resources or by a medical department within the employer, and then oftentimes by a third party such as Cowan or other consultants, and which we increasingly see now, in part because of the privacy concerns that employees express, but also, frankly, oftentimes human resources doesn't want to deal with or have knowledge of, medical issues that might be affecting employees, and there's concerns about confidentiality in the workplace. So it is something that, it's certainly, and obviously the expertise is a definite reason, because oftentimes human resources or others aren't necessarily tasked trained in how to manage absenteeism, specifically when it comes to these types of issues. So in the initial starting point for any absence, and I'm including accommodation because as you probably experience, many times somebody will request, will say it'll start off as a leave of absence, and then they resist the push to get them back to work by claiming they need some form of accommodation, whether it's continued work from home or some sort of a hybrid arrangement, or they may be sort of like, lack of a better term, job shopping and trying to use their underlying disability in a way to have their job tailored differently, or even potentially to acquire a different position in the organization. So all of these involve managing employee medical, whether it's an absence or an accommodation. So first thing first, whether whoever's doing it, the employer is absolutely entitled to request medical documentation, subject only to the Employment Standards Act restriction I noted a moment ago. And if any of you are dealing with collective agreements, sometimes there'll be limitations. It's fairly common to see restrictions on management's ability to request medical until there's 5 days, or it might be in circumstances where the employee has suspicious absences, the Monday, Friday person, or the person who always seems to be sick after their vacation ends and it gets extended by a few days. Generally, there's exceptions to request medical or other information around that. The other important thing to note, and I see this a lot in my dealings with human resources, which is who I obviously typically deal with, you'll often get a terse doctor's note that says, saw this patient, they're totally disabled for the next 60 days. That's all it says. And you're not required to accept that. If it's for a few days, you're past the ESA period, maybe that's good enough. Maybe you don't bother. Context is important. Maybe the employee is not a high flyer on absenteeism, so you can exercise discretion and not require further and better medical if it's appropriate. But if it's an extended period of time, or they're seeking significant accommodations at the workplace or to continue working from home, you can absolutely push back on a brief doctor's note like that and demand further and better information in terms of their restrictions, limitations, and other elements that we'll go through in a moment. And the other thing to bear in mind is it's proportionate, right? So the longer the absence goes on, or the longer they've telegraphed their absence to be, like, I'm going to be out for 90 days or 60 days, you're entitled to more detailed information, and your basis to insist on that is much stronger. Same thing with if they're asking for an accommodation that might present health and safety risks to other employees in the workplace. That's something in which you can absolutely, the employer or through its agent, can demand further and better information, because and a common example is, and I go back to my job shop comment, I suppose, is that some people, they might have a legitimate injury, then they're no longer doing 15-20% of their job, which required heavy lifting or operating certain equipment or dangerous equipment, and they're accommodated for a brief time not having to do that. And that's okay. But when this becomes extended or potentially permanent, it effectively means that other employees have to rotate through the harder work more often because the other individual is being accommodated. And in those cases, again, you can insist on far better information and may potentially deny the accommodation request as a result of the fact that it poses a risk to other employees who are going to be doing the heavier lifting. And in terms of what do you do if you get that cryptic or useless medical note? As I said, you on behalf of the employer, ask for more information. It might be in the form of a letter that you ask the employee to take to their physician. I generally would recommend against liaising directly with the physician unless you're doing it through a third party expert service such as Cowan or those folks. But generally would strongly recommend against HR or somebody in the environment, in the employment environment, doing that themselves, just for medical privacy and other reasons and expertise. So if you do, as the employer, ask information, then you address it to the employee and tell them to take it to their physician, and you ask them for details around what are your restrictions, what are your limitations, What's the prognosis for recovery? What are they compliant with their treatment program? What's the prognosis for this injury or this absence to cease? Those are all things in which you could ask. The other way to go about it is, again, and this gets more into a long-term accommodation or a long-term absence, which doesn't seem to be resolving. Then you might ask for a functional abilities evaluation, or you might even go so far as to have an independent medical examination. For example, if it's a complex psychiatric condition, but the employee is simply providing a note from their family physician that says the employee's stressed out and experiencing psychiatric episodes or upset, and that's it. Then again, they're not an expert in psychiatry, and you can demand either information from an appropriate healthcare practitioner that the employee is seeing, or absent that, if it's just a walk-in clinic GP arrangement, then that might be something. Again, if it's a longer term accommodation or there's no end in sight, then you might want to go to FAE or IME in order to get more probative, more valuable medical information in which to make employment related decisions. Sorry, I wanted to go back to this slide. Obviously, it's always case by case, and I mentioned previously on the other slide. If it's an individual who isn't normally a high flyer on absenteeism, you may not require the same follow up. Or if it's obvious that they broke their leg, you don't need to send them to a physician to get to say that they're restricted from standing for certain time periods. There might be obvious ways in which you don't need to deal with it. But conversely, if you're dealing with somebody who is a Monday, Friday absence, they're always extending their vacation, or they actually, or if they had a recent performance review, or in some cases, they heard that their termination might be pending, or they caught word of a significant downsizing at the employer. All of those things, while not medical, are obviously relevant to consider from the adjudicator or case manager or employer perspective when assessing why is this person suddenly off on a cryptic note for 90 days when they had no other issues, especially if that 90 ends up becoming 180 and so on. So in those situations, it's important to understand whether or not any of those other contextual items are present, because it'll affect management of the claim. It'll be critically important that the employer or the adjudicator, if you employ somebody, or the case manager, that both the employer and if it's a third party, have appropriate policies and procedures in place and protocols around when to request information, when to request further and better information, when to request independent medical or a functional abilities evaluation. Those things are critically important to, it doesn't have to be entirely prescriptive, but there should be some general guidance around when these additional thresholds are met for requiring further information. It helps obviously to administer the claim or manage the absence, but also avoids discrimination claims, because people will often say, well, you're targeting me, you're only managing me. This other employee was absent the other day and there was no requirement of the other week and there was no follow-up. That might be because the other employee wasn't a problematic employee, or it was a short term, or there could be a variety of reasons. But if we don't have these criteria spelled out in a policy and a protocol, then it does leave us open to these types of allegations. And the problem is, under the Human Rights Code, I didn't reproduce that section, but there's essentially a section that if an employee alleges that we've treated them in a certain way as a result of their disability, and they establish that at least it's possible that that's the case, then the legislation effectively requires that the employer disprove that. Right. So they don't have to, the tribunal could infer from how they were treated that, in fact, it was due to disability and they were treated differently. And if we can point to why this individual is different compared to the others, and that we have a prescriptive, not overly, but at least some of the steps to follow, and we can show that we made decisions on reasonable bases, then that provides us the ability to defend the human rights claim if that happens. And increasingly, we see them against employers on these issues, as well as whoever's doing the case management. They'll often lump both parties in, whether it's STD, LTD, or simple absence management. So that's why it's good for everybody to be on the same page and have fairly sophisticated policies. You also, as a matter of first instance, you want to determine whether or not there's any connection to the workplace, both because there may be exclusions under insurance policies around whether or not they're eligible for STD or eventually LTD, because obviously if it's connected to the workplace, there may be exclusions. And if you work for an employer who is subject to the WSIB, then there almost always are exceptions in the insurance policy. So if there is a workplace component to it, then you need to make sure that that's understood and or challenged at the appropriate time, because that will affect what path the claim goes down, as well as whether or not the WSIB protocols and obligations and reinstatement obligations will apply or not. So it's certainly important from that managing the proper path. The other reason, of course, is if the allegation is that it's due to, being harassed by my manager, it's often due to performance management issues, but it sometimes would be called harassment. We can, that needs to be investigated and ideally disproven that no, we were simply managing your employment. We weren't. This is harassment. You're getting additional scrutiny, not because of the disability or not because of any other improper factor. It's because you're a problem employee or you've demonstrated these issues. And so we need to be able to understand if there's any workplace nexus for those two reasons. So that'd be important. I noted sort of refer to this a little bit at the outset. I'm sure you probably all feel the same. Increasingly, a lot of time is spent on absence management and accommodation is based on mental health issues and addiction. And those are difficult issues to handle. There's the Human Rights Tribunal will say the employer or its absent or its claims management folks can't be blind to that, can't be willfully blind. So if there are all kinds of telltale signs the employee was suffering from that kind of a condition or concern, and we end up terminating their employment, for example, and they'll often say, well, it was due to my mental health or it was due to an addiction issue. And the employer or the case management folks said, well, they didn't tell us that in writing or didn't formally disclose that. But if there's other evidence that the employer or the case manager, especially the management, would know that, yeah, there's probably an issue. This person is suddenly missing a lot of work or is suddenly more agitated at work, or there's some different changes, or just obviously clearly impaired in the workplace, for example, then we can't say we didn't know. It'll be difficult for us to defend on whatever that might be. So it can be helpful for employers to provide even just a base level awareness to management about these types of issues, what to look for, how to notify HR confidentially, because you also don't want to create a situation where you've got managers as Inspector Clouseau running around assessing employees to see if their eyes are bloodshot every morning. There has to be a balance, right? And that's why they should only be disclosing that information to human resources, who then can deal with it appropriately. The next point is to ensure that you're treating the absence management process or accommodation process, and sometimes it's a mix of both, right? As you're gradually getting the person to return to their regular duties, that it's not fixed in stone, that we can't say like this is the 90-day window, here's what's going to happen. At the end of that, we expect you to be fully reporting to work, performing all essential duties. We might have to back up a bit if there's a setback and it's legitimate. Conversely, things might improve and you can accelerate the timetable on the accommodation plan or the return to work plan. But it's important to have that plan and to have it evolve just to some extent and be wary that it might, because ultimately there's really two outlets here. We're either managing the absence to get early and safe return to work, or the accommodation, or we're managing it to the point of termination of employment. And obviously, if it's a disability related absence, we can't terminate without cause or terminate for cause, obviously. But there may be the ability to terminate for frustration, and that's recognized by our human rights adjudicators, as well as under the Employment Standards Act itself, which contemplates that employees may be terminated where there are extensive absenteeism or the inability to accommodate their needs to the point of undue hardship results in an inability to continue the employment relationship. And the entitlements in that case are limited to the employment standards, termination pay and severance pay. It's generally a complete defense to any claim by the employee that they're entitled to reasonable notice damages at common law, because the whole idea is that if you're frustrated from employment, you're disabled, then there is no mitigation, and that's what the reasonable notice damages are for, to help you find your next job, and that's not going to apply. Now, it's much easier if you get to a termination for frustration circumstance where the individual is on long-term disability, and especially if the individual goes from being disabled from their own occupation at usually the 2-year mark. Some plans are 1 year, but usually 2 years. Or if it goes, once it gets to the disabled from any occupation, when that happens and the carrier or adjudicator has made that determination, it's generally fairly safe to terminate for frustration at that point, because there is no prognosis for a return and the individual has been found to be totally disabled from employment. So again, all this work that goes into managing the absence is what then informs the employer's ability to terminate for frustration down the road, or successfully get the employee back into the workplace. In terms of what the employer managing the process would be entitled to, you're entitled to the nature of the illness. Obviously, we all know not a diagnosis. You're entitled to know what's the expected date of return and have that updated periodically if it's uncertain or quite far out. You're absolutely entitled to details on their restrictions and limitations. And the other important thing, and this is why, again, it can be helpful to have a third-party expert do this, because HR and others may not have the expertise, but oftentimes you push back and say, "Oh, thanks for that note." Can't tell, obviously, based on the note, but were you seen by the physician in person? Were you assessed by the physician in person? What examination or testing did they perform? You're entitled to ask those questions. Obviously, the responses back will have more meaning to a medical professional or to a claims management, absence management professionals than it would to perhaps you or I. But you're absolutely entitled to ask those questions, and I find it often makes physicians a bit nervous. They're a little more weary of making bold statements around what the employee's capacity is, because ultimately, I would tell, like, my experience, and again, I only deal with the worst of the worst when it comes to legal issues, but oftentimes it's all self-reporting. Sometimes it's just over the phone, or I even had a case where they just emailed the physician and said, "I'm not feeling well, I feel disabled," and they wrote them off for 30 days. So absolutely entitled to push back on that sort of stuff. You're entitled to prognosis, obviously, prognosis in terms of if it's absenteeism, when are you going to be back to work, and updates on that. Or if it's prognosis around restrictions and limitations, and you're able to accommodate, when are they going to get back to full capacity? When are they going to get back to being able to perform their essential duties as required under the Human Rights Code? So you're absolutely entitled to that, and updates on that. And the more that the prognosis becomes uncertain, or the more the physician's initial prognosis was uncertain, it's actually good evidence if we ever get to the termination for frustration argument, because we're able to say, we keep getting 90-day or 60-day prognosis for recovery from the physician, and they're never right. We've got 10 of these now, and we're 2 years out or a year out. And at that point, the fact that they can't accurately provide a prognosis is very good evidence that there is no prognosis reasonably proximate for them to return to work or to return to regular duties. So it's important to follow up with that. You're also entitled in some circumstances to confirmation of compliance with the treatment plan, so that they have a duty to do certain things, whether it's physical exercise, whether it's taking certain medications. You're not entitled to know what those medications are, obviously, but you're entitled to know, are they from the physician, are they complying with the treatment plan as prescribed? Because if they're not, that's a failure on the employee's duty to participate actively in the accommodation process or the return to work process. So certainly something worthy of following up on. And then finally, as referred to in the prior slide, you're certainly able to provide for a specialist opinion if it's, like I said, if it's something that's clearly above and beyond what a GP can assess in their office. And it may be more of a physical assessment. It could be a physical demands analysis, any number of things. I'm not suggesting it always has to be, obviously, only in a psychiatric issue, but consider whether you push back in some instances for a specialist opinion.
John, can I just interrupt you? Because there's been a few kind of questions around this, so I thought it'd be just a good chance to
Sure.
ask this. So lots of questions. Thank you guys for keeping to do that. I'm keeping a list of ones that we're not immediately responding to. One of the questions from a I guess, an employee participation perspective, there's been a few questions around what if the employee doesn't kind of want to participate or provide the reasonable level of evidence that an employer is allowed to obtain? What are often the next steps from an employer's perspective that they could take?
Yeah, so yeah, great question. If they're not, and it happens frequently, unfortunately, employees resist providing further and better medical. Sometimes they just turtle and don't even respond to requests. But at some point, you'll have to sort of, and again, it's important to, you'll hear me ad nauseum probably on this point, but to document this and is to say, like, we need this information on or before X date so that we can make decisions about your whether your absence is valid, whether your request for accommodation is valid. And so you just say that, or maybe not, and maybe it's a more neutral term, the first letter, not that it's valid, but how best we can accommodate your absence or accommodate. And, and then if that date comes and goes, then the next one is a bit firmer and simply, we require this information, whatever it is you've asked for, to be provided by you or your physician or whatever the case may be, on or before X date, failing which we'll make a decision about accommodation or the validity of your absence based on the information we have currently. And that usually means it's not approved. It usually means that there's no basis for the accommodation or insufficient request. And so usually when you put that second deadline to them and they appreciate that it's going to have consequences for not complying, you'll usually get something. If you get nothing after that, then the final, or I should say final, the next step, employers will either say, you're teetering on abandonment, right? I mean, because you have a duty to cooperate and reciprocal. You failed there's actually case law which have upheld terminations for failure for the employee to participate in the accommodation process. So you do have outlets. Some employers won't terminate. They'll simply say you're on an unpaid discretionary leave until further notice, and then you might see what that does and then follow up again and then start back with if you don't provide the information requested, your employment may be terminated. You certainly won't be entitled to the STD or LTD or whatever weekly indemnity benefits might be available. So there are certainly levers that are available to the employer to press for cooperation with the employee, and you're entitled to do that. Obviously, it'll just, if it's with an employee that you've been around the horn on many times, then you could probably be more aggressive sooner and refer to the fact that we've experienced difficulties with you in the past and complying with substantiation requirements. If it's somebody that is first time you're seeing them, you might want to tread a little more gently. And the reality is some employees think that, and I see this sometimes, they're like, you're not entitled to ask me anything. Or they'll say, you're not entitled to know my prognosis or my restrictions and limitations. That's for my physician only. They'll tell you when I'm ready to return to work, or they'll tell you what accommodation I'm entitled to. And that's just legally incorrect. The employer is entitled to relevant medical information or other information to determine whether or not the absence is valid, or to determine whether or not the accommodation request is appropriate and should be given further consideration. So, don't be afraid to push back and educate. And even some physicians, you'll get pushback from physicians sometimes. And I've sent ghost written letters for clients in which we remind the physician of their duty. And there's a information bulletin from the College of Physicians in Ontario, which talks about the obligation on the family physician to facilitate an early and safe return to work. Their job isn't to just write these Dr. Summer-off notes. So don't hesitate to draw in their ability or their requirement to cooperate as well. And I can tell you, just as a quick aside, it's ironic and somewhat amusing. I've dealt with doctors as employers, and to see how frustrated they get when their employee that works at the clinic or whatever it is gets some other doctor saying they're not able to work, or they're feeling harassed, and they're so outraged that there's no detail and where's the particulars, and I want a diagnosis, I can reassess it. And so it's just kind of interesting. It's all about perspective, whether they're the employee's physician or they're the employer of the employee. Hopefully that helped address. And then again, this is part and parcel of what we need to remind employees about, and that is if they're to maintain the absence or to, like I said, a lot of this is evolving out of, I don't want to go back, I have a mental health issue or stress or agoraphobia or whatever it might be, I can't come to the office, and they're asserting disability or some other human rights ground. They're the ones that have to make the request. They have to substantiate the basis for the request and explain it to the extent that the employer or the claims or absence management and people can understand it. And then they need to absolutely provide suitable documentation in order to ground the request for the continued absence or for the accommodation. It's a legal requirement on all employees, and it's well recognized in the case law. So we can certainly push back. As noted, they have the reciprocal duty to facilitate the whole process. It's not a one way, what can the employer do for me? It is a mutual obligation that's shared. And if there's a union in your workplace, they should also be involved in the process to some extent, because they're the exclusive bargaining agent. So technically they have a role in dealing with employees. But B, which is almost more important, you don't want them to be able to lie in the weeds or on the sidelines. And then when the accommodation process blows up and they grieve and they've had no involvement, then, they can be quite difficult to deal with. Whereas if you've involved them at the front end and they see that the employee is the obstacle, the employee is not assisting and facilitating, sometimes that may avoid a grievance. Sometimes they lean on their own union member. Other times, if they do file a grievance, it's great to call evidence at arbitration or at the Human Rights Tribunal that they were in the room with us. They saw the same failure to provide information or the failure to cooperate. So because sometimes the unions are worried about their duty of fair representation and may not get too aggressive with the employee, but it's still helpful to include them at the outset and as the process goes through. Sorry. And I also wanted to deal with it's really critical to note, as I said, it's not what can the employer do for me. The employer's legal obligation is to provide reasonable accommodation to the point of undue hardship. Doesn't mean you have to give what the employee asked for or what they prefer or what the person would love to do. As I said, we often see a lot of accommodation requests where it's like, take out the 20% of the hard labor that's associated with this job, and I just want to do the 80%, even though it's an essential duty, the other elements. And, you can push back based on the substantiation. B, the impact on other employees if they have to rotate more frequently through the harder aspects of the job. And that may amount to undue hardship if it's a health and safety risk to other employees. And you may say, we're not challenging whether or not that's true. We're just saying we can't accommodate it. And then what happens, I'm sure you've all experienced this, sometimes you get evolving restrictions. So it's either, I'm suddenly getting better now because they see that the gig's up and the employer's sort of the walls are closing and they might actually take action in respect to their employment based on the weak medical or the weak restrictions. Or other times I see it where it evolves the other way, where it just gets increasingly, they just don't want to come back. They get to the point where they're basically all they can do is float in the air. They have no ability to walk, sit, stand. I mean, I've seen some pretty crazy material, frankly. And if they do that, you might want to, as the employer, accept that, not challenge it and say, okay, well, the employer relationship's frustrated. We have no, your condition has become progressively worse and your restrictions progressively worse, and we can't accommodate you. So, again, it's a bit of and that's where the case management, absent management people can assist, because they're sort of attuned to those issues and strategizing around it. Because again, the whole point of all of this is either to get the person out the door, that's the cynical lawyer, or get the person back in the office door and working productively. But so you need to be aware of these pitfalls on the way through. Now, in terms of the pitfalls and understanding the risks, we'll cover those fairly briefly, but this one's important only because it's a human rights tribunal case, the TP in Ontario Correctional Services, and there aren't a lot of these, but it does happen from time to time. They have awarded damages, in this case $27,000 in damages for injury to dignity as a result of aggressive disability management. So in that case, they found that I think it was the employer in that case, it wasn't a third party, which is probably part of the problem. They were being extremely aggressive with the individual, very, very tight timelines in terms of giving further and better medical information to substantiate the absence. They were then threatening to cut off benefits, and some demeaning remarks, I think, were even got produced in emails. And that's the thing you have to think about too, right? As HR professionals and others, try to avoid any editorial in your emails or Slack or whatever communication systems you might use, because all of that stuff's ultimately producible in the event that there is litigation arising out of these issues. And it can be pretty damning. And I've seen cases where it's come up and an HR, or usually more so a manager, says, yeah, we gotta cut bait on this person. Even like one case was during the probationary period, and which they could have just HR could have just managed and said not suitable for the role, wish you all the best. But instead, this person emailed all these reasons based on medical concerns the employee had as to why he didn't want to continue working with the individual and didn't want to be bothered accommodating periodic absences. And that sort of stuff getting produced in a proceeding has a significant negative impact on the tribunal or the court or the arbitrator if it's unionized, and their view of the case and their view of the employer and how they managed the absence. You're absolutely going to want to steer clear of that sort of overly aggressive. And again, that's why it's useful to put this in writing, do it through email, because whatever's said on a phone call, unless it's been recorded, it's debatable in terms of, was it an aggressive tone or was it just a forceful tone? Whereas, putting it in writing and using neutral language, provides for a better, cleaner record in the event that we've got to defend any of these human rights, disability, or discrimination cases. Just so you know, it's not all bad for employers. There is this our Court of Appeal case involving the Ottawa Catholic School Board. And they actually, in that case, the Human Rights Tribunal at first instance had found that the employer was indeed justified in requesting an independent medical exam as part of its duty to accommodate, because there were many, many uncertainties around the underlying medical, including whether or not the person providing the GP providing the opinion was even capable, let alone engaging in the type of examination that I referred to earlier is important, and which was a surprise because the tribunal typically is not a terribly employer-friendly body. But in that case, it found that was reasonable. And this was judicially reviewed and then ultimately up to the Court of Appeal in Ontario, and they agreed that that was reasonable. I mean, there are circumstances in which we can demand that the employees submit to an independent medical. Now, of course, you can't chain them to an examination table and require it. But if they refuse to cooperate, then they're either, well, initially they would be on an unpaid leave of absence. And if that persists, at some point the employer might say, if you're not going to do this, we're not accommodating you, or we're treating the absence as being unsubstantiated, then and then leading towards termination for cause in that type of situation because they've not cooperated with the process. Under the WSIB, and I won't belabor this point, I just leave it on there again. For those of you that and are subject to the WSIB environment, there are, it has a fairly detailed early and safe return to work process under the legislation, but also just in terms of your own expertise in dealing with these. And if an employee, and I've been involved in cases where the employee does not cooperate or they're slow to cooperate, and the WSIB will suspend loss of earning benefits or discount the loss of earnings benefits, often to try to get the employee to comply. So there's certainly no problem with the employer doing the same, whether it's WSIB or not. But the employer, if they're not properly participating in the process, as I said, it's reciprocal, then there can be significant penalties under the WSIB in terms of not facilitating an early and safe return to work. You will always be notified in advance by the WSIB if they're doing that, typically verbally, but certainly in writing. And if you get into that sort of situation, then you probably would absolutely want to retain either legal or management, third-party attendance or accommodation management services, because the penalties and the consequences can be quite serious for employers. So just an important additional layer to note in the event that it's the absence or the accommodation request stems from a workplace injury. Now, there are limits, and it's important to bear this in mind when you're going through this process. There is no obligation at law under the Human Rights Code or law of the courts, the tribunal, to remove essential duties. So, or to basically make the job useless, or to provide or make a job for somebody. At the end of the day, the primary process focuses on getting the employee to return to their pre-injury job, whether it's WSIB or whether it's simply off-duty injury or illness. And that's the focus. Can we get this person back to work performing their essential duties? We don't have to bring them back and delete all the essential duties. That's not required. And you don't need to rip apart the job in order to find something that the employee could do with some value. They need to be able to do the majority of the job. Maybe it's 80%, maybe it's 75, maybe it's 90. It'll depend on what the nature of the duties are. But it's not like if it's less than half, then you should be pushing back quite hard. The second step of the analysis is you would, in certain circumstances, especially where it becomes a permanent issue, you might have to consider, to the point of undue hardship, whether bundling some duties together makes for an economically viable job that the person could do. Or in some cases, in a unionized environment, there's been cases in which they bumped out or sort of bypass seniority on a job promotion or a job assignment. Very rarely actually physically bumping another employee out of a job. It would not entail bumping an employee to the street so that the disabled person could retain employment. But in between on that continuum, there are things that you'd have to consider depending on the nature of the illness and the injury. The other important point to note is, especially if it becomes a permanent accommodation, if they're being accommodated in a lesser role, with or without accommodation, if they could do that job but not need accommodation, or they could do it with a bit, and that's where they want to go, and we're okay with that as the employer, you don't continue paying them at the higher rate that they might have been receiving under the other position they had. They're only entitled to be paid in accordance with what the rate of the job is. There's no sort of super priority ascribed to their wage rate because they're being accommodated. Now, if it's for 2 weeks or 4 weeks, maybe you don't reduce their wages over that short of a period. But absolutely, if it becomes a permanent accommodation, give consideration, serious consideration, to paying them only what the job rate is, the applicable job rate. Because in fact, it's a disincentive and demoralizing to other employees who are doing the very same job next to them and earning less pay. And there's nothing in our human rights world that requires you to pay somebody more than what the job is worth because they have a disability. And the same thing is, why sometimes when employees are in extended absence, it's not discriminatory to suspend benefits coverage, because benefits coverage is something that's being given in exchange for performing work. And there's significant case law on that as well. But again, you wouldn't do that until at least 90 days or more, just so you don't engage unnecessary litigation, but also it's more defensible the longer it goes on. And I just include this one case law point because it is fundamental. It's a case that we all go back to from the Supreme Court of Canada in 2008. It's a Hydro-Quebec case involving an employee with substantial absenteeism over the course of several years. And in that case, the union was essentially arguing that, they do come to work sometimes. So, and how is it undue hardship for the company if they're not at work and they're not getting paid? What's the problem with that? So basically just accommodate this crazy absenteeism that was 30 days plus each year. And this went all the way up to the Supreme Court of Canada, and they said, well, hold on, there's a fundamental employment relationship here that requires work in exchange for pay, and dependability and trust, and as the foundation for the employment relationship. And they said it was appropriate in that case to dismiss for frustration, or innocent absenteeism, it's sometimes called, where there's no foreseeable change. And as I said, that can be because the doctor said there's no foreseeable change, and you have a note to that effect, then proceed with frustration-based termination. Or it could be that the doctor gets it wrong 12 times and you have no idea when this person's regular capacity or regular attendance will resume. Or it could be that the doctor keeps saying, oh, they're ready, and it keeps changing. Then the court or the tribunal will look at the totality of the employee's attendance record, and they'll expressly conclude, this history is good evidence of what the future is going to be like. If you've got multiple years of substantial absenteeism, then the court or tribunal will look at that and say, well, that's a good indicator of what the future holds, and the employer should not have to tolerate that indefinitely. as I indicated, the prior attendance record, or if you've accommodated the individual for quite some time and they're not getting better despite promises, that's relevant to whether or not you look at an alternative accommodation or whether you look at termination for frustration. Same thing with if there's no expectation of reasonable attendance or return to essential duties, that might lead you to frustration. You also need to ensure that the employee is given some sort of I say warning verbally. Here you see counseling. Everybody gets nervous if you talk warning language in the attendance management context because it's not supposed to be disciplinary. It's non-culpable. The reasons they're out, it's not their fault. It's a condition or an injury. But you still have to just advise them. There's nothing wrong with telling them that you've missed 22 days this year. Our average is 8. Or hey, just reminding you over the past 2 years, you've missed this many days. What can we do to help you improve your attendance? In an invited discussion either with HR or with third-party case management services. But you can't just surprise them with you're terminated for frustration. If you give them no forewarning, what often happens is they magically recover the day after you terminated them. And then when we're in litigation, right, the employer or the plaintiff's lawyer will say, oh, look, they got this medical a couple months after they're terminated from their physician, clearing them from all restrictions, or all they needed was this magic intervention and now they're fine. And if it's probative, legitimate information, then sometimes employers have difficulties with that because you didn't provide the employee with the notice that how serious it was getting and that their employment might end. So it's important to do it for that reason as well. And then ultimately, as with everything else in employment law, the onus is on the employer to establish all of these things, right? That there's no prognosis, that the patterns have been atrocious, that they've been appropriately counseled and cautioned and offered assistance, and nothing seemed to work, then you're pretty well situated to implement termination at that point. I sort of referred to the first point earlier, but this concept in human rights law, just the difference between participation and compensation. So as I said, things that accruing seniority, for example, that continues as part of you participating in the workplace. Even though you're away, you're still accruing service seniority, whether under the collective agreement or for termination severance pay purposes under the Employment Standards Act. That's life, and that's what our courts have accepted. But as it relates to compensation entitlements from the workplace, whether it's benefit coverage, salary, perquisites, whatever it might be, there's it's a very strong foundation in our law that you're not entitled to free compensation. It is a relationship where you render service in exchange for compensation. And if the employee is not doing that, then the employer's obligation to provide compensation can terminate. So so it's important to remember remember that, and it's also why I say to you, consider paying the person in accordance with the applicable job if they're accommodated in a lesser role and it becomes important. Safety, as I mentioned earlier, and that can be safety to other employees because of the rotational duties I mentioned, or it could be if you're dealing with somebody in a safety sensitive environment who has has a physical restriction that prevents them from doing certain things safely. For example, like a point of contact, pulling themselves up into a vehicle or a tow truck, a lift truck. They can't just say, oh, it's okay, I'll waive that. Let me just do it with one arm and pull myself up, or a stool or something. The employer doesn't have to allow and shouldn't allow the employee to accept risk. There's no legal requirement to do that, because the reality is if the person injures themselves, the employer will be on the hook, either through personal injury litigation if they're not under WSIB, or through WSIB, or even the Occupational Health and Safety Act. There would be charges against the employer for allowing that to happen. So safety is a very important one. The other part of safety, the final note I would make on that is if you're dealing with somebody, again, very safety conscious environment. If the individual is a recovering addict and they've worked before under the influence and they've had a safety incident, or even if they haven't, if there's no assurances from their physician, and I usually get them to demand that. And they usually won't because they walk it back. But that the person is fit and safe to return to work, and they, essentially guarantee the person will remain fit and safe. If you're not getting those assurances from an appropriate healthcare practitioner, that's another basis to say we're not returning you, and you're out there on an unpaid leave until you take an in-house program, like an in-person counseling treatment or whatever it might be. So again, you don't have to just roll over and provide whatever it is the employee's asking for. I've already covered the top-up wages issue and the eventual termination for frustration. I just have a note here about last chance agreements, often used in the union environment, but I also deploy them in the non-union environment. And I find they can be helpful to say, especially if somebody's got a history of brutal attendance or addiction and relapse, it can be helpful for the parties to essentially, it's like a formal agreement that sort of says, look, we've accommodated this, you've missed this many days over this many years, we spent this much time, this much money, whatever it might be that you've done to accommodate. You put all that in the document. A, it brings it home to the employee, but B, it also sets it up for eventual termination, or in some cases, the employee reads it as a last chance agreement. If they don't get their act together, their employment's at an end under the terms of the agreement, and they'll only get employment standards at most if it's related to disability. And it also, if they later file a human rights code complaint, it's good evidence of our accommodation efforts, whether on attendance or on modified duties. So it can be an important, useful tool, and sometimes it does succeed. Like as I said, the employee actually responds to it when they see what the employer's done, and it's right in front of them, what the impact has been on other employees, and the fact that they've signed something that says, absent sustained improvement, their employment's at an end. So something that I think would be certainly find useful. The frustration, which is that other end path, right? So if the return to work process doesn't get them in the office door, it gets them out the office door through frustration. And this just sort of neatly summarizes the legal principles. But ultimately, the idea is, just as its name implies, the employee relationship is frustrated because it's not the employee's fault if it's a legitimate disability, nor is it the employer's fault. Through no fault of either party, the relationship's impossible to perform, that they can't do the work for the compensation that was agreed to. And if there's a prolonged disability or illness or a permanent impairment, sometimes that might happen immediately. If there's a serious permanent cognitive impairment, or God forbid, paraplegic or something that, that might be the end of the accommodation analysis right then and there. But those elements are all required. The other important point to note is always check with your insurance carrier to make sure that if you terminate for frustration, that it does not have an impact on their continued benefits eligibility. And normally it doesn't. The vast majority of agreements I've seen with Manulife, Sun Life, and the other big players, for example, as long as the employee's disability arose while they were employed and they started the STD or LTD process while they were employed, the fact that they're subsequently terminated does not normally negate their ability to go on to LTD. And if they're on LTD or can go on to LTD, they're much less likely to challenge any adverse employment consequences. So definitely check that. And then finally, I see it's 11:57. This is the final slide. I'll just leave it there, and all of you, I think, will get access to these slides in any event. But I just sort of set out at the end of the day, ensure that you go through a timely and ongoing return to work process. Get out early. The longer the employee's out, the longer they're likely to stay out. Keep them engaged. That is your best opportunity to get them back in the workplace. Think about other avenues for information, whether it's psychological assessments, FAEs, IMEs, any number of things. Make sure that if it's a case where the employee is requesting accommodation, that you consider what available work there is in the workplace and have it documented that you've gone through that analysis. You can't just sort of say, well, I wouldn't think they could do anything, and so we terminated. I mean, the Human Rights Tribunal has awarded damages where an employer properly terminated for frustration, but because they didn't go through the process. So they were lucky that the tribunal agreed with them, but they still got punished with a damages award because they didn't properly go through the case management process. And then obviously meet with the employee. If there's a union involved, as I said, make sure you involve them. It can't hurt. Document, including, and this is the advantage of third-party case management, absent management services. They have to have really good case notes. They're used to doing that. We have a chronology with brief notes about the nature of the discussion. You have like a nice ready-made exhibit in the event we're ever challenged on termination to show all the efforts that were made to engage the employee and accommodate them. Same thing when you're offering accommodation or you're cautioning them about their absenteeism, make sure it's in writing so that we have a record. And then lastly, if it's WSIB, use them, work with them. They can be helpful in terms of leveraging compliance by threatening benefit coverage, loss of earnings benefits and things. And then, of course, if you're using an LTD carrier adjudicator, obviously they'll have the most of the relevant information, and that would be something important to follow up with them. So I just made it out of the wire. I appreciate everyone's time, and hopefully you found this of interest and useful. Hi, Ryan.
Sean, thank you very much. Yeah, exactly on time. Good job. So I'd say there's a number of QA questions. So thank you guys for making use of the chat function. We've recorded all the questions that we never got a chance to answer, and we'll be posting that on our microsite. We will be sharing a copy of the recording and the deck very shortly after the presentation today. So I thank everyone for taking the time to meet with us today and present with us. Thank you, Sean, for your time today. And we wish you all the best and have a happy lunch.
Take care, everybody.